I'm on mute, right?
Justin Morgan for respondent, Mr. Joaquin Rivera. Mr. Joaquin Rivera is here as well.
All right, are both parties ready to proceed?
Yes. Yes, sir.
All right.
All right, everyone, please be seated. Were you able to pick up your child?
I was. Thank you so very much.
Oh, no problem. Just let me know. I was like, please don't let there be a child standing out there like, where's my mom? All right, if you could place the witness back on the witness stand, please. And Deputy.
We're on me.
Oh, on me. Okay. If you have a seat and watch the hump. And you're still under oath.
Yes, ma'am.
And you may resume your question.
Thank you, Your Honor. Morning, Joaquin. What is a layout?
A layout is a basic format before we do anything, we're doing an OCW, or it's kind of an introduction into things of what the therapist has to do. He tries to get us to memorize it. And sometimes it's kind of difficult because sometimes correction needs to be made. Sometimes it needs to be adjusted depending on the grooming techniques and what we use.
Will you present your layout to the jury?
Hopefully I don't make no mistakes, but my name is JOAQUIN RIVERA Senior. I was charged with aggravated sexual assault of a child. I sexually assaulted an 8-year-old female child who was a family member. I sexually abused one other person. I groomed the individuals that I sexually assaulted and sexually abused by lying, manipulation, and pornographic material. I recognize now that I used denial of intent to groom the individuals that I sexually assaulted and sexually abused. I recognize now that I use minimalization to recognize myself and also the lack of empathy that I put forward to the individuals that I sexually assaulted and sexually abused.
Have you worked on empathy while you've been in treatment?
They've been teaching us on everything as far as like putting ourselves in victim letters, victim personalizations. They have us flip around to what we did exactly did to the victim, but putting our said, which is pretty much like I was doing this at this time. This is what happened to me, and that's pretty much what they instill on you. Is pretty much putting yourself in a victim stance of what happened, with everything from dot to dot, point to point, what you were going throughout the day, and it's pretty intense.
Do you recognize yourself now as a victim from when you were abused as a child?
No, for the fact that you grow out of it, you got to move on with your life. You can't stay dormant in the past. It's considered trash, but even trash can be recycled.
As part of today, as you sit here, are you motivated to continue your change?
Yes, sir. And it's just not gonna, like I said, it's a lifetime registry, so it's a daily reminder. It's gonna be, you mature. This is, I didn't learn nothing from all this going on. Me sitting in front of the ladies and gentlemen here, it's something's obviously wrong.
Now, in treatment, was one of your first courses watching a movie called They Call Me Mr. Trejo?
Yes, sir.
Who is Mr. Trejo?
Mr. Trejo, he would be Danny Trejo. He's now a movie star. You can see him in like movies called Anaconda, Con Air, examples. But he also did time in a prison. He came out and rehabilitated. He's been sober for so many years. I think he's like in the 70s now. But he sets an example of abstinence, of changing your mind. The machismo and all the pride. Not to use it in the wrong way, but to use it as far as for the betterment of humanity.
Was that movie a motivator for you to accept the change that they were offering?
Yes, sir. To me, it was because it's more understandable because somebody that actually been behind bars and actually been through a situation like that, and he came and overcame the statistics of saying that he wasn't going to come back and refuse them. And even though he wanted to prove that I could do this, I found that he could do it, and I could do it. There's change possible.
What is a therapeutic community?
Therapy community is we call it a brotherhood, sort of a family, and it's divided up into certain departments. You got your coordinators, your expediters, your accountants, Toastmasters, rec. It's pretty much combined all in one, and it's pretty much they're giving us lessons on how to speak properly, how to better present yourself within out here. It's kind of a halfway point, getting out of the transition of being behind the bars and having that state of mind into being able to come back into civilization, to the free world. But also, they teach you the prerequisites of what's going to happen in therapy class, what's going to happen in their psych ed, whatnot. They give you kind of a little basic program to understand it before you go in there. There's also the education part, so individuals have any questions, we could ask somebody that's maybe in charge of education department, how do I do a layout, how do I do an LCW, or what do they mean by an ACR, which is like I said, alternative coping response, along them lines. It's pretty, and we also hold each other accountable. When we do something wrong, we have something that's called a ticket. And we present the person first. I'll come at you out of care and concern. You violated whatever number of rule it was. Say you left something in the day room, or you made a mess and you forgot your stuff in the shower area, or what the case may be, or you were being negative to another inmate. We come at and we hold ourselves accountable for that too, and we learn from it. Further action needs to be done that there is something which we call an SOD, sex offender director.
Do you consider yourself an alcoholic?
Yes, sir. I'm not going to say I'm not, because that's pretty much the first step, is acknowledging that you have a problem. That's from the AA teaches.
Do you consider your use of alcohol to be, when you were out, to be excessive?
I would drink. Fortunately, I was working out there in the sun, so you're working hard work. You might drink a couple beers after work. That was pretty much what it was. And then, of course, on weekends, after the bills were paid and whatnot, and whatever little money was left over, we invest in a bottle or something and some beer. Barbecue. Cut the grass. That was considered a party. It's concerning certain cultures. So that's what we looked at.
Did you have any medical issues related to the alcohol use?
Yes, sir. I was diagnosed in 2014 with cirrhosis of the liver. I've been going through, we went to Gallatin, our main hospital is Gallatin Hospital, so yearly I've been making, since pre-COVID, 2-3 visits for CT scans, ultrasounds, I can't remember the terminology, but we run cameras down your throat, run cameras through your anus area for colonoscopies, and so I've been going through all that due to my alcoholism, for cirrhosis.
Do you have any long-lasting effects from it?
I have what they explained to me is when you have cirrhosis of the liver, it's like a filter for whatever comes out your stomach. It breaks down and goes through everything else. Well, cirrhosis is also it can't be healed, but it scars. Think of it like a sponge. It's hard to break stuff back, so break it down, so it backs everything up. So it causes acid reflux, serious acid reflux. So it's hard to even drink water sometimes to go down. So that's the whole part of that camera down your throat thing. That's to check to see if there's any blood vessels that swell up. You can tie it up with rubber band.
Have you ever used alcohol in prison?
Yes, sir. My first couple of years, my first few years, I did consume what they call hooch, homemade wine, and that's pretty bad. That kind of pursued it more. It intensified. This is before I was diagnosed, and our bodies are made out of sugar, so thinking we know if it's made up, it's done. Well, of course, as soon as you drink it, it's activating your body again. So it affected my liver. So I stopped.
Was that during the this sentence or a previous one?
It was beginning of this sentence.
So alcohol is available in prison?
They, not, you can't buy it. But now they put up restrictions on certain items with churches that's where you can make it. So they put big restrictions on that.
Did you victimize Jasmine?
Yes, sir, I did.
Did you victimize Lorraine?
Yes, sir, I did.
If you could go back and change your life, would you change those actions?
It was a possibility that we go back in time for it. Yes, sir, I would.
In treatment, did you discuss the ripple effect?
Yes, sir, it was considered, I guess, equal to like 40 persons. They gave us a 40-person worksheet to where write down everybody that's been affected by this crime, including not just the victims, not just the victim's family or me or my family, but also concerning the therapists, the parole officers, the jury, the people here in this courtroom, the officers that arrested me, their families, everything down the line. We had to actually go in, the officers, the TDC officers, their families, but we don't know their families, but just people that they gotta, it causes, in other words, it's like you throw a rock in the pond, it causes that domino effect, a ripple effect. So it's everybody that's been affected just for this crime that we went through.
When is your discharge date?
Objection, Your Honor, relevance.
Sustained.
Well, they've already admitted a conviction for failure to register. I think it's important for Joaquin to talk about how that's not going to happen in the future.
Sustained.
How old were you when you got the conviction for failure to register?
Was 29.
Are you the same person now that you were at 29?
No, sir.
Do you have the insight and the maturity to make sure that you keep up with the registration?
Yes, sir. Not only the insight and the journey, but also the tools, the remembrance. As far as the fear of heart, the case heart.
Joaquin, do you have anything else to tell the jury today?
Objection, Your Honor, calls for a narrative.
Sustained.
Joaquin, did you ever go to trial?
No, sir. It's my first time.
Is this the first time you've ever sat in the witness chair?
Yes, sir. It is my first time being here.
Is it difficult to open up in that chair?
It is, you know, it is a bit, like you said, they train us in therapy and therapy community to kind of open up about everything. So that in itself is hard. But it's a big difference having that talking, you know, outside the source of therapy, you know, community or therapist, or somebody that's actually another sex offender. You know, it's hard to kind of open up and help. So there's no telling what goes in the mind of everybody.
Pass the witness, Your Honor.
My petitioners.
Thank you, Your Honor. All right, Mr. Rivera, you were talking about alcoholism a few moments ago, and I believe you testified the first step is acknowledging you have a problem. Is that right?
Yes, sir.
And would you agree that in order to fix a problem, you need to know what that problem is?
The basic format, yes, sir.
Mr. Rivera, did Jasmine do or say anything that made you think she wanted to have sexual contact with you?
No, ma'am, she,
Do you And yesterday, I believe you testified that you were taught to protect the widows and the orphans.
Yes, ma'am.
Were you also taught to protect children?
Yes, ma'am.
As the witness.
Respondent.
No further questions.
All right, you may step down. Petitioners, any other witnesses?
No, Your Honor, at this time, the state rests.
Respondent.
Respondent will rest, but we do have something to take up outside the presence of the jury.
All right. And petitioners, do you close?
Yes.
Respondents, do you close?
I would like to take something about the presence of the jury first. And then,
Okay. All right, ladies and gentlemen, the jury, I'm going to give you a break now. There are some things that we need to go over, not just with this case, but with also the court's docket. But you will be hearing closing arguments from both sides possibly today. Okay, I say possibly, but so I'm going to have you all back here at 10. And remember what I said, you're not allowed to deliberate until I give you instructions to deliberate, and don't discuss what you've heard amongst yourselves. All right, everyone, please rise for the jury. All right, I will hear your argument.
thank you, Your Honor. At this time, respondent will move for a directed verdict. Because at this time, the jury does not have sufficient information or has no information to come to a decision or answer the question asked to them. They've been presented with only 2 witnesses. And it is incumbent upon the state to present sufficient evidence for the jury to be able to make a determination beyond reasonable doubt that a person suffers from a behavioral abnormality. That must come from a professional opinion. The professional opinion today is far from bridging the analytical gap between the research and the opinion. In fact, it contradicts the Supreme Court case law regarding these proceedings. The presentation from Dr. Dunham discussed how JOAQUIN personally is doing well in treatment, he's moving forward in treatment, and that in his opinion, will complete treatment. He has developed a level of self-control. It's just that the opinion of the expert says that's not enough for him. That's not a determination for the jury to have to consider. And the other thing is that under Kansas v. Crane, the Supreme Court, there's got to be a serious lack of control or a showing of a serious lack of control of behavior. The 2 convictions show a lack of control. However, those are far remote from who JOAQUIN Rivera is today. And I believe that even the testimony of the state's expert suggests that he is on his way to being able to be released into society without having to be civilly committed. If JOAQUIN goes back to TDCJ, he will go back into treatment. He will finish that treatment program. He will parole and have 2 years of parole to help support him and monitor him. And that would include super intensive supervision. It would include GPS monitoring, secondary GPS monitoring, mandated sex offender treatment, mandated alcohol and substance abuse counseling. And it gives him the opportunity to establish himself in the community and have the security there that he can develop. The jurors are not going to be told what the outcome of this is until after they make a decision, and they do not know, and they can't make the understanding of whether or not this person is a sexually violent predator under the legislative findings of the small but extremely dangerous group of persons that are sexually violent predators who are not amenable to traditional treatment modalities. I think here we have a clear case of somebody who is in his current state amenable to traditional modalities of treatment, and that by not allowing that to flow out would do a disservice to JOAQUIN. It would also do a disservice to the citizens of the state of Texas because it's more costly to go through the civil commitment proceeding, which is in a locked environment where there is a definite deprivation of liberty. So at this time, I would ask for a directed verdict on the information regarding the behavioral abnormality being proven beyond reasonable doubt, because he does have control, he does have the ability to control, and he does have a present shown ability to do that.
Yes, Your Honor. The standard for direct verdict is that there was basically no evidence to bring an issue into dispute. I believe you brought Dr. Dunham and Mr. Rivera that at least with both of these issues, I apologize, both these elements, repeat sexually violent offender and behavior abnormality into dispute. The comment about serious difficulty controlling behaviors, case law says that it is encompassing behavior abnormality, is not a separate element for us to prove.
All right, respondents, it's your oral motion, so I'll give you final argument.
I'm sorry, Your Honor.
I said it's your motion, so I'll give you final argument.
Thank you, Your Honor. It's incumbent upon the petitioner to prove beyond reasonable doubt that JOAQUIN has a behavioral abnormality, which is a congenital or acquired condition. Let's say that Dr. Dunham's testimony established that there is this condition, and that condition is pedophilic disorder and antisocial personality disorder. The behavioral abnormality has to be that condition that by affecting the person's emotional or volitional capacity. I think we have evidence here that the emotional volitional capacity is not affected by that condition. Now, if the person's, let's say, for example, the emotional or volitional capacity in this state at this day of JOAQUIN is affected, does it cause the likelihood of him to commit a sexually violent offense? There's a lot of different things that I think we have in play here that will prevent him from committing a sexually violent offense, particularly parole, but other things like his stance in life. And then that has to be to the extent that the person is a menace to the health and safety of another person. And to me, there are dangers in this world that we know of, and there's dangers in this world that we don't know of. JOAQUIN has now had to go through a catharsis, and he is making a complete turnaround. There's no evidence that he has this behavioral abnormality because there's no evidence that he is or going to be a menace to the health and safety of the state of Texas.
All right, respondent's motion is denied.
Thank you, Your Honor.
Have both parties had a chance to review the new jury charge?
Yes, Your Honor. Sorry, water went down.
Oh, it happens all the time.
Yes, Your Honor.
All right, are there any objections to the new jury charge as presented, petitioners?
I don't have an objection. It's kind of more of a comment. On the first page, it looks like sexually violent predator is emboldened, and then the elements are normal except for the and. So attention is And then the definitions are emboldened. I don't have problems with what's emboldened, but if maybe we can do both elements emboldened as well, that way the jury's clear, these are the two things we have to prove. It kind of takes notice away from.
So you're asking for which parts to be emboldened?
On the first page,
Yes.
down at the bottom, under definitions, under sexually violent predator,
Mhm.
the 1 and 2 is a repeat sexually violent offender and suffers from behavior abnormality that makes the person likely to engage in a predatory act of sexual violence. Since that's what we have to prove, I think it's just kind of. So the other definitions of bold and kind of.
So you want number 1 and number 2 in bold print?
Yes, Your Honor.
Is there anything else?
No, I mean, and that's not a real objection, it's just no real.
All right, respondent.
Yes, Your Honor. Yesterday, we discussed the question having no before yes. On page 1, it still has yes before no. And then this draft does not have the 10-2 split, so I will object to that. Under chapter 841, even though that this is this case started prior to September 1st when the new law came into effect. And that law and the instructions in that said that they were going to apply to any hearing or any proceeding, regardless of when the case was filed. And here, not only was the case filed prior to September 1st, there was at least one hearing held that I think would start the toll for a proceeding. And that would have been docket control hearing. I think would have been the first. And that was before September 1st as well. So I would just put that objection to the denial of the 10-2 on the record.
All right, petitioners?
Are you asking for a response?
Yes.
I'm sorry. Yes, Your Honor, the enacting language for the new law says very clearly, regardless of when the petition is filed, that new law takes into effect. So it would go in, I'm not sure, but it would negate Jones, so to speak, the case law that says the 10-2 is proper for a no. We would just argue the new law goes above that.
All right, then that will be denied to the respondents. Now, respondents, with regards to the bold print, do you have any objections to all of that being in bold?
It would, to me, it would be heavy, but I have no objections to it if they want all of that bolded.
Okay, so then with regards to the yes, no, the staff writer is changing it to no, yes. And then she will embolden number 1 and number 2
Thank you, Your Honor.
on page 1.
And then yes throughout. Yeah. Okay.
And so we'll do the no, yes throughout. All right, if there is there anything else with regards to the charge other than those changes?
No, Your Honor.
No, Your Honor.
All right, we're going to take a short break. Can you place us on mute for a second?
All right, jury.
All right, everyone, please be seated. All right, respondent, do you close?
Yes, Your Honor, I just want to close.
Ladies and gentlemen of the jury, you've heard all the evidence in this case. I'm going to read to you what is called the charge of court. You will have a chance to have a copy of what I'm reading to you back in the jury room. Charge of the court. Ladies and gentlemen of the jury, after closing argument, you will go to the jury room to decide the case. You may discuss the case with the other jurors only when you are all together in the jury room. In deciding this case, you are instructed to answer one question. You will answer the question either no or yes. All jurors should deliberate on the question. The question you will answer in this case is as follows. Do you find beyond a reasonable doubt that the respondent, JOAQUIN Rivera, is a sexually violent predator? Definitions. You are instructed that a person is a sexually violent predator for the purposes of Chapter 841 of the Texas Health and Safety Code if the person, one, is a repeat sexually violent offender, and two, suffers from a behavioral abnormality that makes a person likely to engage in a predatory act of sexual violence. A person is a repeat sexually violent offender for the purposes of Chapter 841 of the Texas Health and Safety Code if the person is convicted of more than one sexually violent offense and a sentence is imposed for at least one of the offenses. Behavioral abnormality means a congenital or acquired condition that, by affecting a person's emotional or volition capacity, predisposes the person to commit a sexually violent offense to the extent that the person becomes a menace to the health and safety of another person. Predatory act means an act directed towards individuals, including family members, for the primary purpose of victimization. Sexually violent offense means any of the following offenses. One, continuous sexual abuse of a young child or children. Two, indecency with a child by sexual contact. Three, sexual assault. Four, aggravated sexual assault. Five, aggravated kidnapping if the person committed the offense with the intent to violate or abuse the victim sexually. Six, burglary of a habitation if the offense is a first-degree felony and the person commits the offense with the intent to commit A, continuous sexual abuse of a young child or children, B, indecency with a child by sexual contact, C, sexual assault, D, aggravated sexual assault, or E, aggravated kidnapping if the person committed the offense with the intent to violate or abuse the victim sexually. 7, murder or capital murder is determined beyond a reasonable doubt to have been based on sexually motivated conduct. 8, attempt, conspiracy, or solicitation to commit any of the offenses listed in items 1 through 7 above. 9, an offense under prior state law that contains elements substantially similar to the elements of the offenses listed in items 1 through 8 above. Or 10, an offense under the law of another state, federal law, or the Uniform Code of Military Justice that contains elements substantially similar to the elements of an offense listed in items 1 through 8 above. Choosing a presiding juror. When you go into the jury room to answer the question, the first thing you will need to do is choose a presiding juror. While all 12 jurors will participate in deliberations to decide the question, the presiding juror has the following specific duties. 1, have the complete charge read aloud if it will be helpful to your deliberations. 2, preside over your deliberations, meaning manage the discussions and see that all of you follow these instructions. 3, write out and sign any questions or comments you have for the judge. Knock on the door and give them to the bailiff who will give them to the judge. Write down the answer you agree to on the verdict form. 5, sign the verdict certificate on behalf of unanimous jury. And 6, notify the bailiff that you have reached a unanimous verdict. Do you understand the duties of the presiding juror? If you do not, please tell me now. Does everyone understand the duties of the presiding juror?
Yes.
Instructions for answering the question. 1, remember the instructions that I gave to you at the beginning of these proceedings. Do not discuss the case with anyone else, either in person or by any other means. Do not do any independent investigation about the case or conduct any research. Do not look up any words in dictionaries or on the internet. Do not post information about the case on the internet. Do not share any special knowledge or experiences with other jurors. Do not use your phone or any other electronic device during your deliberations for any reason. 2, do not let bias, prejudice, or sympathy play any part in your decision. 3, base your answer only on the evidence admitted in court and on the law that is in these instructions in the question. Do not consider or discuss any evidence that was not admitted in the courtroom. 4, you are to make up your own minds about the facts. You are the sole judges of the credibility of the witnesses and the weight to give their testimony. But on matters of the law, you must follow all of my instructions. 5, if my instructions use a word in a way that is different from its ordinary meaning, use the meaning I give you, which will be a proper legal definition. Number 6, a jury determination must be by unanimous verdict. This means that all 12 jurors must agree on your answer. Number 7, if you have unanimously decided on a verdict, then the presiding juror may sign the verdict certificate for all 12 jurors. 8, the question and answer are important. No one should say that the question and answer are not important. Number 9, do not decide who you think should win before you answer the question and then just answer the question to match your decision. Answer the question carefully without considering who will win. Do not discuss or consider the effect your answer will have. Number 10, do not answer the question by drawing straws or by any method of chance. 11, the burden of proof in this case rests solely on the petitioner, the state of Texas. Petitioner must prove its case beyond a reasonable doubt. The burden never shifts to the respondent, JOAQUIN RIVERA, to prove that he is not a sexually violent predator. 12, the fact that the respondent has been alleged to be a sexually violent predator by the state of Texas gives rise to no inference of him being a sexually violent predator at his trial. Additional instructions. A fact may be established by direct evidence or by circumstantial evidence or both. A fact is established by direct evidence when proved by documentary evidence or by witnesses who saw the act done or heard the words spoken. A fact is established by circumstantial evidence when it may be fairly and reasonably inferred from the other facts proved. Hearsay is a statement other than one made by the declarant while testifying at trial, offering evidence to prove the truth of the matter asserted. As a general proposition, hearsay is not admissible. However, certain hearsay information contained in records reviewed and relied upon by the testifying expert has been presented to you through that expert's testimony. Such hearsay was reviewed by the expert and has been presented to you only for the purpose of showing the basis of the expert's opinion and to afford you an opportunity to decide the weight and credibility to be given to the expert's opinion. You may not consider this hearsay information for any other purpose, including whether the facts alleged in the records are true. You must consider the opinions of the expert, but you are not required to accept the opinions as true and correct. The meaning and importance of any opinion is for you to decide. In evaluating the believability of the expert witness, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied on reaching that opinion. You must decide whether information relied was true and accurate. You are instructed that the statements of counsel made during the course of this trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any statement or comment made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. If you do not follow these instructions, you will be guilty of juror misconduct, and I may have to order a new trial and start this process over again. This will waste your time and the party's money and will require the taxpayers of this county to pay for another trial. If a juror breaks any of these rules, tell that person to stop and report it to me immediately. Do you understand these instructions? If you do not, please tell me now. Does everyone understand the instructions?
Yes.
When you have answered the question, you are required to answer under these instructions, and the verdict certificate is properly signed as instructed herein. You will knock on the door and inform the bailiff at the door of the jury room that you have reached a verdict, and then you will return to your seats in the courtroom with your verdict. Respectfully submitted, Judge Stephanie Boyd of the 187th District Court, Bexar County, Texas. With regards to the knocking on the door, when the deputy takes you to the jury room, she will actually instruct you. There's a buzzer instead of a knock on the door. All right, suitable verdict forms are attached, and I will turn it over to petitioners for beginning of their closing argument.
Thank you, Your Honor. May I please support petitioner for response? Well, good morning. We've reached the end, right? You've just been read the charge and you're about to go back and start deliberating. So I do want to take a moment and say thank you all. We know this takes a lot of your time, a lot of your attention. It's not an easy subject matter to listen to. So we really do appreciate your time and your attention. We can't do our jobs without you guys, and the criminal justice system, the legal system can't operate without you guys. So thank you. So I do want to kind of remind you guys of a few things right before you go back and start deliberating. I know you're probably sick of seeing this question, but just to remind you, this is the question that you're going to be answering. Do you find beyond a reasonable doubt JOAQUIN Rivera is a sexually violent predator? And the two things that Jacqueline and I had to prove to you beyond a reasonable doubt was that Mr. Rivera is a repeat sexually violent offender and that he suffers from a behavior abnormality. So I want to review some of the evidence you saw. Remember, you saw that Mr. Rivera has been convicted for indecency with the child, and he was given 5 years. This was in 1999. He went to prison, got out, and he did it again. He was convicted of aggravated sexual assault of a child against Lorraine, and he was given 15 years for this offense. And you heard the judge take judicial notice that these offenses are in fact sexually violent offenses. So remember that repeat sexually violent offender is at least 2 or more offenses, and a sentence has been served for at least one of them. We believe we clearly met that with the penitentiary packets, and there was no evidence against that. So then we look at this second element, right? This behavior abnormality. And I believe Jacqueline told you at the beginning, we were going to spend a lot of time on the second element. And you saw that's what we did. We brought you, well, first off, I apologize. Here's that convoluted definition. The condition that affects him, basically, that makes him a menace to the health and safety of another person. And so we brought you Dr. Jason Dunham, right? And he told you, yes, Mr. Rivera does have this behavior abnormality. But he didn't just give his opinion and get off the stand, right? He explained to you his own qualifications, right? And you have his resume and evidence. You can take it back and look through it if you want to. But he told you he's a licensed psychologist. He's done hundreds of these kinds of evaluations, both here and in Washington. And he explained the methodology, how he typically conducts an evaluation like this. He told you that he looks at all kinds of different records, has an interview, and then scores some instruments. And that's how he reaches his decision. And he told you that he did that with Mr. Rivera, right? You heard that Dr. Dunham looked at, I think he said 1,000 to 2,000 pages of records, and you heard all the different entities those records came from. And then he had that 2-hour interview, right? He didn't just base his opinion on the 2-hour interview. He looked at all of the records and the interview, and then he made some diagnoses. He listed out his risk factors, and that's how he came to the opinion that Mr. Rivera has that behavior abnormality. So let's look at some of this, right? Dr. Johnson told you basically his behavior abnormality really is a pattern, an ingrained pattern of behavior over time, and it is seen through these risk factors, right? The sexual deviance. You have the 2 sexual offenses, those convictions that we talked about, and you heard that there was that abuse actually went on for longer than was reflected in those pen packets, and Dr. Dunham had to take that into consideration. He also looked at that persistence after punishment. You heard that Dr. Dunham say, most sex offenders, if they get caught, sent to prison, they don't do it again. They learn their lesson. They're done. Not Mr. Rivera. He got out and he did it again. And he escalated. He went from fondling an 11-year-old to penetrating the anus of a 6 or 7-year-old. That's a problem. That's concerning. And that's what Dr. Dunham said. The age of the victims, I just mentioned that. That's concerning. And that points to that pedophilic disorder, right? Dr. Dunham explained there's that pedophilic disorder, and seeing that behavior over time. It wasn't just a one point in time thing. It was over a long period of time. And then you have the level of force, the callousness during the offenses. That was concerning to Dr. Dunham. So, Mr. Rivera was in a relationship. He was married at one point during that first offense, and he was in a serious relationship. He called her basically his common law wife during that second offense. He had access to an age-appropriate sexual partner, and he chose to offend against little girls. That's concerning. I've already talked about escalation, and then you had that unrelated victim. It was his girlfriend's daughter. That broadens that victim pool, makes him a little more dangerous, ups his risk a little bit. That antisocial personality disorder. Remember, Dr. Dunham explained these are the 2 umbrellas, sexual deviance and antisocial, but together, the combination, he has a full-blown antisocial personality disorder, and he has sexual deviance. That's a very dangerous combination. And he told you, basically, it's this long history of acting out. He's been getting in trouble with the law for a very long time, not just the sexual offenses. You heard about burglaries of a habitation and so forth. And that's concerning. That's adding fuel to the fire. These probation violations, again, you heard that he can't follow the rules, and that he showed that while on supervision. You've installed, you have a penitentiary packet and evidence, that violation of the registration. He can't follow the rules. That's concerning. Drug and alcohol use. Dr. Dunham explained, look, there was evidence there of cannabis use disorder. I believe he said cocaine use and alcohol use. We give him credit. He's in remission, but there was evidence that he used it, and so that ups his risk a little bit. And also that remission is in a controlled environment, so that's a little concerning. But he did give him credit for that. In remission, but it's still there. He had to consider it. And then expelled from school and violence against his ex-wife. That again ups his risk a little bit. That's concerning to Dr. Dunham. All right, then you heard about the instruments that he scored, right? The static 99R, you got to see it for yourselves. You got to, I went through it with Dr. Dunham with the 10 items myself, and you heard that he scored a 3 on this. Dr. Dunham explained, look, this instrument says he's an average risk. However, he would have scored lower beforehand. Still reoffended. He's already blown the stats out of the water. He's reoffended 100% of the time. That's concerning. So that's why I said, look, this shows average, but really he's a high risk. That's concerning. The PCLR, remember that psychopathy checklist. And I went through with him, what are the big things that you saw with this? And he listed that conning and manipulative, a little bit of a sexual lifestyle. That's a little concerning. But he did not diagnose him with full-on psychopathy, right? And then he's like, look, I always look at protective factors, positive factors. I didn't see anything that rose to the level of protective, but we want to give him credit where credit is due. He's in sex offender treatment. He's progressing, he's trying, but it is not enough to reduce his risk. This is a pattern, long pattern of behavior he's showing in 8 months of treatment. He's just not there yet, but we give him credit for, look, he's in treatment and he's trying. Age, again, it was a positive, but not quite all the way to protective, along with the good institutional adjustment. He's done well in a very controlled environment. Again, we give him credit for this. We don't want him acting out in prison, but he had that before. He had a few disciplinaries before, and again, he escalated. He went to a younger victim and escalated the sexual violence he did on that little victim. So they don't quite rise to a protective factor. So we would argue that this meets behavior abnormality, I want to say beyond all doubt, but definitely beyond reasonable doubt. And so the answer for this question is very clear. He is a sexually violent predator. Thank you.
Respondent?
Thank you, Your Honor. I want to take a moment to thank you. These are tough cases. They're not difficult to hear. They weigh on you physically, emotionally. That's why it's great that they're not long trials, because I don't know if any of us could go through it 2 weeks. I started off earlier in this process by talking about how we do have the best system of justice in the world, because it takes 2 sides to argue in order for us to get to the middle, us to understand what's going on, for us to make decisions. And we do that in everyday life. Here's no different. The only difference is that we ask you to kind of suspend that bias when you're listening and make a informed decision at the end. And I know you've all been very attentive. You've been listening. No one fell asleep. And I do want to thank you for that, because I do know how trying it is. 2 days ago, Justin and I left the courthouse. We drove to our hotel, and it's maybe 4 blocks from here. Took us about 10 minutes in traffic. We left yesterday. I was exhausted. I was tired. I was hungry. I was thirsty. I was dehydrated. I get in the car again, and we're driving. I somehow get us onto a one-way street. Justin goes, "You want the navigation?" I said, "No, I got this. It's just right over there." We almost end up to the needle. He goes, "You want the navigation?" I said, "No, I don't want the navigation. I got this. It's right over there. I've stayed in this hotel before." I almost turn on a one-way street the wrong way. And at that point, I pull over and I said, "Justin, either you're gonna have to drive or I need the navigation." Justin says to me, "Thank you. Thank you for being honest." And he turns the navigation on the wheel. Right? That's how much of a toll it can take on us. Is it's tiresome. It drives into us. We're listening. We're focused. But now we're at the end. Now we're going to give it to you, and everything that you need to answer this question, you've got. You've heard it throughout the testimony of the two witnesses that testified here, and the exhibits that have been admitted. Now, in the opening statements, the opposing counsel said something that I think rings true. That this case is really about what lies beneath the surface. She went on to talk about how JOAQUIN will talk a lot of words, and you have to filter those words and look at what's beneath the surface of those words. But that goes to the other witness as well, Dr. Dunham. Dr. Dunham said a lot of words. And you've got to look at what's beneath the surface of those words as well. Now, we've talked about the burden of proof. It's the highest burden that we have. Same as any criminal case, and it's the state's burden. They have to prove beyond a reasonable doubt every part of this case, whether or not the person is a repeat sexually violent offender and whether or not the person suffers from behavioral abnormality that makes them likely to engage in a predatory act of sexual violence. So let's talk about what the state presented to prove to you beyond a reasonable doubt this question. They presented a Dr. Dunham. Now, Dr. Dunham, he reviewed a lot of records. I think he said several thousand pages of records. He did a 2-hour interview with JOAQUIN. That 2-hour interview was over a teleconference through a computer. He said that was adequate. He said it's not preferred, but it was adequate. Dr. Dunham gave you his opinion. And like you've heard before, we ask you to suspend your bias. I don't have to suspend my bias when I'm here. The state doesn't have to suspend their bias. Dr. Dunham doesn't have to suspend his bias. But you, we ask to suspend your bias when you're answering this question. Now, Dr. Dunham did say he's not predicting the future. He says nobody can predict the future. But he also told you that he does risk assessments. 100% of his time is forensic, with the exception of every once in a while maybe helping out somebody. In this case, he's not here to help anybody. And he defined these risk assessments as how likely a person will do something in the future. And then he went on and he defined likely as a pretty good chance that something will happen. So here we have a 2-hour interview over a teleconference that's adequate, and a risk assessment determining how likely a person will do something in the future. And his opinion is that it's a pretty good chance. Now, he presented a lot of risk factors. And early on in this proceeding, you heard the 2 biggest risk factors for predicting sexual recidivism are sexual deviance and antisocial lifestyle. And then Dr. Dunham said, no, those aren't risk factors. Those are concepts. These are the umbrellas, right? And underneath those are risk factors. And Dunham said that the biggest predictor of future behavior is past behavior, right? Well, if that's the case, he could have stopped after looking at the records. If that's the case, then Mr. Trejo would still be in prison. Now then something happened and the biggest risk factor became an offense after being convicted. Now that's concerning. Right? It's nothing's good about that. I mean, when I do these cases, there's usually nothing great I can say about the facts of the history of my client. And there's no difference with JOAQUIN. But I still ask myself how many of the biggest factors there are. Because it seems like every time I ask a question, it changed. Every time I asked a question about a statistic, something else became the biggest factor. Why did it change like that? And I'll tell you why. Because when you don't know the statistics, you just make it up. Now, Dr. Dunham scored a PCLR, psychopathy checklist revised. 20 questions, we went over it. There's all these traits, these characteristics. He determined that he's not a psychopath. That's great. But he goes through all this stuff and he says, there's close link to antisocial personality disorder. Now, it's somewhat rare to find somebody in prison that's a psychopath. Okay. But he also said that it's very common for people to have antisocial personality disorder. But let's think about this. The PCLR is not a snapshot of who JOAQUIN is today. It's a historical view. And we can't change that. We can't change his juvenile history. We can't change his young adult history. We can't change anything. Now, Dunham listed these characteristics for JOAQUIN. He talked about fighting, truancy, stealing, drug use, alcohol use, juvenile issues, failure to register. And he said that's all before JOAQUIN was age 29. And all of that is going to affect the score in that PCLR. All of that is going to go into the characteristics of antisocial personality disorder. But what else did Dr. Dunham tell you about anti-personality disorder? Was that, he doesn't exhibit the behaviors that other inmates with antisocial personality disorder exhibit. Now, I asked Dr. Dunham once, you said that he's all over the place when you were reviewing this deposition. Did you want to call him? No. Why not? Well, I don't know. But I asked him if it would have made a difference, or could it have made a difference if he called him to get clarification. And he said, yeah, maybe. The other thing he said is that he's doing well. And he does seem motivated. He does seem to have at least a minimal, and that's the opinion of the state's expert, a minimal understanding and insight of his behaviors. So then he went on and talked about the static 99R. This is the most used actuarial in these proceedings, right? And he told you he does this methodology called a clinically adjusted actuarial approach, right? And I asked him, I said, how is a clinically adjusted actuarial approach versus a pure actuarial approach methodology? Right? He said it's more, it's more accurate. And I said, what about a pure clinical approach? He said, using the clinically adjusted actuarial approach is more accurate than a pure clinical approach, right? So what he says was, you've got to take the science and you've got to use that to help screen for subjectivity. You've got to take that science and you've got to listen to that science to make a determination. But what did he tell you? It's not accurate. What did he tell you? It's not accurate for JOAQUIN. So where is the clinically adjusted actuarial approach for him? If you don't use the static, if you don't use the actuarial, he's reduced to a pure clinical opinion. And that pure clinical opinion, he said, is no better than the flip of a coin. Now, Dr. Dunham talked a little bit about statistics. He said he doesn't have them, he doesn't present them. He said, but I will talk about them if asked. Well, I asked him a lot about statistics. I stopped short because I think we were all getting a little blazed. But the fact was he didn't know any of them. And I held up the professional workbook. I said, they're in here. How many times have you been asked these on stand? A lot. I've asked him many times. Bring the workbook. Don't phone it in. Do your job. He could not define what relative risk ratio was. I just moved on. I'm like, so here we have a static, and it says that there is a predicted recidivism rate within 5 years of a person with a score of 3 at 6.5%, which means 93.5% chance that Joaquin Rivera,
Objection, Your Honor, this is a misrepresentation. I don't think it made it into evidence either.
All right, ladies and gentlemen, the jury, you will remember the evidence as you heard it.
I do believe that Dr. Dunham agreed with the book when I said 6.5%, and the math would be that over 90% of the time, when Joaquin walks out of there, he's not gonna reoffend. And there's a good reason why he's not gonna reoffend. There's a good reason why he's not gonna reoffend, because he's got motivating factors. One of the biggest is he's been broken down. He's tired, he's older, he's mature. He's giving up that attitude. Just like when I was driving home yesterday, and I was like, no, I got this. Sometimes you have to put aside that ego. Sometimes you have to check your machismo. Sometimes you've got to let it go. And you have to accept the help. Sometimes it doesn't happen. We've all had family members that have problems. We've all had people that have gone through things and said, you know what, I've got this. And they go on to do it again. We've also seen those same people turn over a new leaf. It's no different between me, no difference with Joaquin, no difference with Mr. Traylor. Now, you heard from Joaquin on the stand. And one of the weirdest things I think ever for a defense attorney is to have your client on the stand and talk. But it's important. It's important because what you hear is honest. You hear a person that says, you know what? I'm not hiding. I'm done. I'm going to tell you exactly what I know, what I can remember, and it's not good. It's hard to listen to, it's hard to hear, it's hard to say. But he has to do that. And he has to do that every day for the rest of his life. Now, Dr. Dunham did come to some protective factors that didn't raise to the level of, or positive factors that didn't rise to the level of protective factors. Now, I want to talk a little bit about this, because if I'm a psychologist and I'm evaluating somebody that says, you know what, I didn't really, you know, I knew where I was going. I didn't need that help. You know, I didn't need that help. I could have figured it out eventually. You know what they call that? Denial. They call that minimization. But here you have somebody saying, oh, these are positive but not protective. That's minimization. And the worst part about it is it's minimization about a human being. That's from a psychologist, forensic psychologist that's not here to help anybody. Now I want to go back to the law real quick. You're asked one question, whether or not the state proved beyond reasonable doubt that Joaquin Rivera is a sexually violent predator. You know that that's two parts. We're not even going to argue about the repeat part. He talked about it, he admitted it, he talked in detail about it in front of you. So it comes down to this behavioral abnormality. This behavioral abnormality that is a congenital or acquired condition. That can be anything, according to Dr. Dunn. That by affecting the person's emotional or volitional capacity predisposes them to commit a sexually violent offense to the extent that they become a menace to the health and safety of another person. All of that, likely, not defined. When you take into what Dr. Dunham talked about, his interview was adequate. You know, he looks at likely as a pretty good chance. Doesn't look at the statistics. That's what's presented to you. And you're asked the most difficult question you're ever going to be asked. Is Joaquin Rivera a sexually violent predator? And that, Dr. Dunham, is what you have to take back there. That's tough. Now, you owe it to the state, you owe it to Joaquin You owe it to our system of justice to go back there and talk about it. This is a difficult question, and there's a lot of things below the surface that have to be addressed. But I want you to think about one thing before you go back there. And that is the fact that there is another factor, and it is a positive factor. And that's the human factor. And if somebody, even if it's a minimal grasp of understanding their behavior, and you see them open up like you saw JOAQUIN on that stand, that's a person that's not a sexually violent predator. That's a person that is flawed and has done terrible things, but is done. He is broken down. Now, I'm going to sit down here in a minute, and the state's going to come back to their second part of their closing. And they're going to tell you a lot more stuff. They're likely to go back into the details of the offenses. Already heard it. They're likely to go into Dr. Dunham and how great he is. Already heard it. They're likely to attack me personally. That's okay. Now, when you hear those things, you're gonna hear doubt. Because you've already heard it. And if they come up here and regurgitate it again, they're just trying to drive a point about reaching to your sympathetic, looking out for the children, right? You can't do that. You have to suspend your bias. You have to suspend that. We're not asking you to sympathize or emotionally connect with JOAQUIN. We're asking you to do the job of evaluating this, looking below the surface of what has been presented. Now, if they come up here and they don't say any of those things, then that's just how powerful the word likely is. But when you hear doubt, you hear more doubt. And like Mr. Morgan told you earlier, all you need for reasonable doubt is one doubt and be able to attach a reason, right? Think about a puzzle. Put together a puzzle. You may think you know what the puzzle is. There's a few missing pieces. But you never know what's under that missing piece until you put it together. And if there's a missing piece on that in that puzzle, you owe it to the state. You owe it to the system of our judicial system, and you owe it to JOAQUIN RIVERA to answer no to this question. Thank you very much.
Petitioner.
Thank you, Your Honor. May I please record? Counsel. All right, so counsel just said a few things that I want to address, and I'm going to just jump right in here. He mentioned we did an opening statement. We got to look at what lies beneath the surface. Mr. Rivera is the one on trial here. But I will tell you, if you heard for yourselves, Dr. Dunham's opinion, it made sense. No matter what question he was asked, he's like, I looked at it all. I gave him credit for good stuff that was there. But at the end of the day, the information points to he has a behavior abnormality. There's no other way around it. He looked at it all. You heard that Dr. Dunham doesn't have to suspend his bias. Well, you heard that he did. You heard Dr. Dunham said there's a treatment provider and there's an evaluator. I am not here as an advocate for Mr. Rivera. I am not his treatment provider. I am an objective evaluator. I look at the information, I have a conversation with them, and I score the instruments. That's what he's asked to do, and you heard that's what he did. This whole comment about best predictor of future behavior is past behavior. If that was true, he could have just looked at the records. We have to look at who Mr. Rivera is today. And Dr. Dunham understands that. He said, yes, it's the best predictor. However, I still have to give the full picture of who Mr. Rivera is. I have to have that conversation with him. I have to get as much information as I can. My opinion is going to be accurate. And he did all of that. Just because that pattern of behavior was so prevalent doesn't negate what he talked about with Mr. Rivera. It just showed he's not there yet. We give him credit, but he's just not there yet. And at the end of the day, that's where we're at. He's not there yet. He didn't have the stats memorized, or counsel said he didn't know the answers for the statistics. You heard Dr. Dunham say, look, I don't have it memorized. It's a lot of numbers. And really, with Mr. Rivera specifically, he blew those stats out of the water. He already did it again. Those stats look at reconviction. That means someone has to go out, find a victim, groom the victim, offend against the victim, get caught, get arrested, convicted, all of that within 5 years. Mr. Rivera did it in 4. He got out in 2004, offended in 2008. He blows those stats out of the water. So you can remember that when regarding those statistics. Said there were a few, the council said there were a few antisocial traits missing. Dr. Dunham said there's really 1 trait missing. He's been good in prison. He doesn't have a lot of disciplinaries. Again, that's a good thing. We give him credit for that. And he had it before. And he escalated. He did well in prison every single time he was there, all 3 times. He escalated. He got out, did it again, did not learn his lesson. This comment about how Mr. Rivera has been beaten down. That's interesting because Mr. Rivera said he was actually beaten in prison the first time for being a sex offender. Got out, escalated. That's concerning. We all heard that, look, he's trying to better himself. And again, this is a good thing. We give him credit for this. But it's not enough. This is a long pattern of behavior, and he has been beaten down before, and it has not stopped him. He has been given every deterrence, ladies and gentlemen. He went to prison. He was given that sex offender education program. He was registering as a sex offender. He was under supervision, and it didn't stop him. You had heard Dr. Dunham say he lost his son after that first offense, and it didn't stop him. He's been given every intervention, and it has not stopped him. That's the pattern of the behavior. Again, he's starting down the right road. He's just not there yet. He's not there to reduce his risk. He still has this behavior abnormality. Even if he has a minimal grasp. You just heard counsel say, even if he has a minimal grasp. Minimal grasp is good. That's a starting point. However, it's not enough. He thinks he's safe to be around children. He said he's at no risk to reoffend. That's concerning. That shows lack of insight. He understands there is a problem. Again, we are at the first step. That's a good thing. But he even said you have to know what the problem is to fix it. And he doesn't know what that problem is. He doesn't understand he is sexually attracted to little girls. When you have a romantic partner, an age-appropriate sex partner available to you, and you still choose to offend against little girls, that's not unmet needs. That's a sexual attraction to little girls. And that's a problem. He needs to understand that before he can move forward. All right, counsel mentioned that he was able to get up on the stand and give you all of the information regarding his offenses. That's interesting. I had to impeach him on how many times he offended against Jasmine. He should know that by now. And I had to impeach him on it. Claimed he was, claimed he had time to recollect his thoughts. He hasn't had much, you've heard he hasn't had a lot of treatment since I deposed him. And then he said, I thought I was teaching her. That was the reason he gave. I thought I was teaching her, but later he said it was unmet needs. Those should be the same answer. He should be understanding the problem at this point. He's 8 months into treatment. He's not there yet. He's giving differing answers, and you got to see Dr. Dunn didn't call the pre-treatment provider. He didn't reevaluate or have an interview with Mr. Rivera to clear up that offense cycle. You got to see for yourselves. He can't keep it straight. He knows the terms. It's a good thing, but he can't understand them for himself. That's the problem. We talked about Lorraine. He'd gone to prison. Been beaten up for being a sex offender, yet he claimed he didn't know it was wrong when he offended against the second victim. That's concerning. And then he told her not to tell her mother, right? He didn't think it was wrong. Why try and hide it? Asked if he was attracted to his victims. He said, I was attracted to my unmet needs. So that's a lack of understanding there. I asked him, if you need to know what the problem is, you need to know the basic format. Yet he denied sexual attraction to children. So again, by his own words, he says, I need to understand what the problem is. And he doesn't understand that. He claims, I already mentioned, he claims to be safe around children. You heard him say, I have nieces and nephews. You heard on testimony this morning. He's like, look, I'm going to be registering. I'm older now. I'm different, I believe were his words. He's already planning to be around children. He has not changed. He was living with a woman and her kids while he was registering. And he's ready to do it. He's ready to be around children again. That's a problem. That is lack of insight. I asked him, what is the biggest thing you have learned in treatment? And he gave me kind of some terms, again, good things, terms. But when I asked him, you told me something different at your deposition, right? We talked about empathy at your deposition. That was the biggest thing you learned. And he was like, well, it all goes together. It's all really empathy. These answers should not be deferring, ladies and gentlemen. This is showing he doesn't really get it yet. Again, down the right road, but doesn't get it yet. That's concerning. He testified that his triggers were unmet needs, yet I had to impeach him. You told me at your deposition it was porn, alcohol, and drugs. He should know these. By now, he should know these, and he doesn't. That's concerning. All right, you heard that Dr. Dunham scored Mr. Rivera on the PCLR for lack of or shallow affect. You got to see that for yourselves yesterday and today. Did you see any real remorse? Did you see really any emotion when we were talking about those offenses? What does that tell you? So, and then there was a comment made by counsel about looking out for children. Part of the law says, or part of that behavior abnormality is menace to the health and safety of others. So yes, you are looking out for the public. It's a menace to the health and safety of others. So it is part of that definition, and you do have to look at it. So there were comments made, an opening statement by counsel about how you have to look at him today, but he can't change his past. That is true. We are here to look at who Mr. Rivera is today. But his past is very important to who he is today. It's a part of him. All of this makes up who he is today. He can't change what he did in the past, but he made those choices, and that's part of who he is. And if he is to move forward into the future safely, he needs to understand his problem so that he can move forward. And he's not there yet. So again, Dr. Dunham explained, this is the bad combination. This is that behavior abnormality, that pattern of behavior, that sexual deviance, that antisocial personality disorder. He's saying good words. That's a good thing, but that's surface level. And this is the real underneath problem. And this is his behavior abnormality. His risk has not been reduced to the point he no longer has this behavior abnormality. And this, I kind of just broke it down for you, right? The definition calls for a congenital or acquired condition. That's that sexual deviance or the pedophilic disorder. That is the antisocial personality disorder. You have part of the definition is affecting his emotional or volitional capacity. He's shown he's done it. He's offended in the past. He got out, he did it again. And I mean, he's shown us with his actions, and actions speak louder than words. You've also seen, or the definition also includes predisposes him to commit a sexually violent offense. That's the risk factors. And again, the extent to a menace to the health and safety of others. That's the public, and that's those little girls. He even said, look, I'm safe to be around little girls. He doesn't understand. That's a problem. So yes, at the end of the day, there might be a hole or two you want answered, but you can clearly see that picture. You don't need every single piece to see the truth that Mr. Rivera is a sexually violent predator. So at the end of the day, we would ask you to return a verdict of yes, he is. Thank you.
All right, ladies and gentlemen of the jury, I'm going to send you back to the jury room to deliberate. You've heard all the evidence in this case. One of the alternates is going to go back with you, and one of the alternates, I need you to stay in the courtroom. And which alternate is going to stay with us?
Angelica Mancinas.
All right, Angelica Mancinas. Okay. All right. Do you have any items in the jury room?
I do.
All right. So we're going to let you go then to the jury room to remove your items because you will not be a part of the deliberations. You were selected as an alternate. All right, everyone, please rise for the jury. Go on mute.
Judge, you're muted.
All right, and we are ready. Is everyone able to hear me now? Mr. Lamori?
Yes, Your Honor.
All right, the court is going to call 2022 CR 1615 Texas versus Nicholas Courtney. Can I have parties announced for the record for the state,
Brittany Sparks.
for the defense?
Amir Memorial?
And are you Mr. Nicholas Courtney?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Courtney, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video conference. Next, I'm going to show you a document entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Mr. Memori, I'm going to show you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Courtney, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Courtney, I'm going to show you a document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault on a bodily injury to a security officer? That is a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court would find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Courtney, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And Mr. Courtney, I'm not ignoring you. I'm signing a couple of documents. Just give me a moment.
Yes, ma'am. Thank you.
All right, we're back on the record. Mr. Courtney, I'm going to show you what's entitled plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, your fine is to be assessed at $1,500 probated. The state recommends deferred adjudication. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is that a plea bargain agreement?
It is, Judge, and I'd like to address the court off the record for a moment when you have a chance, please.
Yes. Do you want to do that before we continue with the plea or no?
Yes, please, Judge.
All right, and is this something that you want in a breakout room that's not broadcast?
Yes, Your Honor.
All right, everyone, just give us a moment before we continue. I'm going to open breakout rooms. When I open up the breakout rooms, please do not go. It will invite everyone. All right, I'll see you in breakout room number 1. Do you want the state there as well?
Yes, Judge. Yes.
All right, and Ms. Sparks, if you could go to breakout room number 1, and everyone just give me a moment. All right, we are back on the record. Mr. Courtney, I'm showing you the, I'm sorry, let me backtrack a little bit. Defense, was that the plea bargain agreement?
Yes, Your Honor, it was.
State, is that the plea bargain agreement?
Yes, Your Honor.
Mr. Courtney, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
No, ma'am, I'm not sure what that means.
All right, so with regards to waiver of appeal, your attorney or you, if you don't like when the way something is done, or if you think that a ruling was incorrect, you can ask someone else to sort of check that homework. Do you understand that?
Yes, ma'am.
All right, and that's what's called an appeal, or at least it's done through an appeal process. Do you understand?
Yes.
In this case, you've entered a plea bargain agreement. Do you understand that?
Yes, ma'am.
So if I follow your plea bargain agreement, the only appeals or do-overs you can have is if your attorney has previously filed some motions. Do you understand what motions are?
Yes, ma'am.
All right, so if your attorney has filed motions and I've ruled on those motions, then that's something you can appeal on. Do you understand?
Yes, ma'am.
All right. Mr. Memori, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with Nicholas, Gentile, Gentile, and the MIC mild evaluation. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence to support the defendant's no contest plea.
Yes, Judge. State offer states Exhibit 1 and all attachments.
Any objections?
No objections, Your Honor.
Mr. Courtney, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it at all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
I'm sorry?
Could you repeat that? I'm sorry, I missed that.
That's okay. Did you understand that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement today, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed states exhibits 1 and attachments, and the court is finding that there's sufficient evidence to find you guilty. However, the court is going to defer finding of guilt as you've applied for deferred adjudication. I'm going to set this for a sentencing date, Mr. Courtney. To Rebecca, I'm going to want a MIC mild evaluation and a TAP evaluation. Mr. Memori, is there any other evaluation you feel that will be helpful to your client?
Not at this time, Your Honor. I think everything will be covered on those evaluations.
Okay, let me get us a date. Everyone, just give me a moment, please.
You're the five for that.
Hi, I need a PSI date for Nicholas Courtney. All right, thank you. Bye-bye. All right, Mr. Courtney, we're going to come back on April 20th. On that date, I'm going to make a decision on your application for deferred adjudication based upon a report that I'll receive for probation and any other evidence that's presented to me. Do you understand?
Yes, ma'am.
All right, what I'm going to do is I'm going to send you to a breakout room and probation will go over.
I'm gonna go ahead and take it to court if we're gonna wait that long.
Yes. All right, Mr. Courtney, I'm going to send you to a breakout room with probation. And I'm sending you to breakout room number 1.
I'm gonna go ahead and ask
I'm sending
for
you
the
to
jury.
breakout room number 1.
Yes, ma'am.
Judge, Ms. Hudgens is in for a status update. Do you want me to take care of that before I go over?
No, I'll send you over there first, and that way we can have Mr. Courtney sent back.
Okay, thank you.
And Mr. Memori, you can go to breakout room number 1 as well. Thank you.
Yes, Judge.
Right. And then where is Ferguson?
I think we're all here, Judge.
right.
Christine, and it says 187 Ferguson, what 14D?
He doesn't have his video on. There he is. All right, Mr. Ferguson, can you unmute for me, please?
Yes, ma'am.
All right. The court is going to call 2021 CR 4559, State of Texas versus Rodney Ferguson. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the
Christine
defendant?
McDonald, sorry, Judge, Christine McDonald for the defendant.
And are you Mr. Ferguson?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Ferguson, I'm sure you a document entitled Defendant's Consent to Appear by Video. Did you review
Yes.
that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ferguson, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, we're proceeding on the lesser included offense of assault, bodily injury, married cohabitating on count 2. We're waiving count 1 in the enhancement allegations.
Any objections?
No, Your Honor.
All right, Mr. Ferguson, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on a lesser included offense in count 2 of assault, bodily injury, married cohabitating? That's a class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand that?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ferguson, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you represent?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you what's entitled plea bargain page. Did you review the page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitating from count 2. Punishment is to be assessed at 1 year in the Bexar County Jail. There's no application for community supervision or deferred adjudication. There's an affirmative finding of family violence, credit for any time served, no contact with Angela Ferguson. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review this paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses, well, then to the lesser included offense in count 2 of assault, bodily injury, married, or cohabitation. How do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence to support the defendant's no contest plea.
State offers State's Exhibit 1 and its attachments into evidence.
Any objection?
No objection, Your Honor.
Mr. Ferguson, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review
Yes,
that document with your attorney? Did you
Yes, ma'am.
understand? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statement and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
That's what it was. It makes me feel sick to think that I'm gonna be going. I'm really worried about not being able to, I get some kind of.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're just respectfully requesting that you consider our plea agreement with the state judge.
All right, the court will follow your agreement. And as previously stated, the court is finding you guilty of assault, bodily injury, married cohabitation. Court will set your sentence at 1 year in the Bexar County Jail. There's an affirmative finding of family violence. The court will give you credit for any time served. There should be no contact with Angela Ferguson. What is the status of his time at the county?
Judge, he has 369 days.
All right, then the court will show that the judgment is satisfied. Mr. Ferguson, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it? Mr. Ferguson?
He's on mute.
All right, Mr. Ferguson, hold down the longest key on the keyboard. Yes.
Okay, yes, ma'am.
Did you review that document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you
Yes, ma'am.
understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over the definition of weapon or ammunition, you'll need to contact an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Ferguson. We can go off the record. Mr. Ferguson, it sounds like you should not be in a relationship just yet. Do you understand?
Oh, yes, I know that.
All right, so here's the thing. This is what I tell everybody. No disrespect intended, but you know the most difficult plant to grow, and I consider myself a green thumb. It's an orchid. So one of the ways to determine if you're ready for a relationship, you can go to Walmart, HEB, all the orchids are out. They're beautiful. They're on sale. I think now they're at $10.65. When you get that orchid, it has all the blooms on it. It's great, right?
Yes, ma'am.
Wait till that orchid loses all its blooms. And until you get that orchid to bloom again, you're not ready for a relationship. And I say that because orchids take a lot of patience. I had an orchid that my staff got me, which I always tell myself, I love it. All the blooms fell off, and you know what? It hasn't bloomed since. I have one little leaf that's sticking out the corner that tells me it's still alive. So do that for me, all right?
Yes, ma'am.
All right, good luck to you. And remember, you're not to have any contact with Ms. Ferguson, okay?
Okay, thank you, ma'am. You have a
All
good day.
right. You too, have a great rest of your day.
All right. Thank you, Christina.
Of course. Thank you.
All right.
Bye-bye.
Judge, I'm sorry to interrupt, but Ms. Hudgens is my client. If she's here for, well, she's my old client.
Oh,
If
we're gonna take that up right now.
Can I stick around in case she has questions on what's happening today?
Oh, yes, most definitely.
Thank you.
All right, Deputy.
So that's it for me?
Yes, that's it for you, Mr. Ferguson, but don't leave yet because the deputies don't like you wandering around. I'm gonna have someone call so they can let them know you're done, okay?
Yes, ma'am. Thank you.
Could you call the other attorneys back? Okay. All right, thank you. All right, so on Ms. Hutchins, what is happening?
Judge, this is just a status update on the DDRF transfer. She's pending medical, she has a dental hold right now. They couldn't give me a timeline as far as how long that's gonna be, but when she's medically cleared, it's a 3-week wait.
All right. I'm sorry, Deputy Mejia, could you call in the back and let them know I don't have a file on Hutchins? Is that an indicted case?
On Hutchins?
Yes. Is that
Yes,
case-
Judge.
All right, so just 1 second, they're gonna bring me the file.
Yeah, this was just a status update today.
Okay. So what's the status?
She has a dental hold.
Okay. All right, we gotta get when you say dental, are we talking about teeth?
Yes.
Okay. So you have a dental hold, Ms. Hutchins.
I'm not quite sure what that is, ma'am.
It's concerning your teeth. Did you apply for something?
Yes, they put me on an antibiotic because they think I have an abscess, but the pain stopped. I don't know.
Well, you know what they say about antibiotics? I'm not a doctor, but they say you have to take that till you completely finish that regimen.
Yeah, it's 14 days.
All right, so they're saying that there's a hold and there's a dental hold. So until that dental hold is cleared, they're not going to transfer you. Do you know how many more days you have left?
I started it last week, so it should be coming up.
Okay.
They only put me on the antibiotic for 14 days, but I know that I didn't want to get anything pulled or anything. I just wanted to get it looked at.
Well, that's the thing. When they want to send you, they want to make sure that there's no type of infection or anything. So that's what the holdup is now. So we're putting you on our docket, but when we put you on our docket, we're doing it as sort of like a phantom setting. so that nothing will stop you from being transferred. So that's the issue right now, that 14 days, okay?
Okay.
Judge, may I ask, can we possibly get another status setting at the end of when she's supposed to stop? And may I have notice and appear on her behalf, Judge?
Oh, yes, we're definitely gonna do that. I'm gonna give a date now.
Thank you.
You're welcome. Vacation? Ms. Hudgens,
Yes, ma'am.
what date did you start taking your medication?
I think it was Wednesday of last week.
That'll put us at councils. That'll put us at March 29th then, I'm thinking.
So after any medical holds, then it's about a 3-week wait, Judge.
All right, so let's just bring her back on March 29th to see where we are.
Am I through, ma'am?
Just one moment. All right, so we're gonna come back on March 29th, and Ms. McDonald, I'll make sure that the court coordinator knows to include you in that.
Thank you so much, Judge. Can I briefly speak to Ms. Hudgens in a breakout room?
Yes, I'll send you to breakout room number 2.
Thank you.
Your Honor.
You're welcome. Ms. Hutchins, you know, my first dental appointment when I was a young child, they showed a bunny rabbit with 2 teeth, and they said you only need to floss the teeth you intend to keep. After that, I floss after everything.
I brush my teeth a lot. I just don't know what's going on. Thank you.
Oh my gosh, good luck. I know that can be very painful though.
Thank you.
You're welcome. All right, everyone, just give me a moment, please. Can you take this to Norma? Everyone on that, we're not on the record, on that question, the normal answer is you have.
Ma'am, you got muted. Mr. Mallory. Mallory?
Yes.
Are we almost through? I didn't know if I was through or not.
No, the judge, I need to address the judge. Just be patient, please. Thank you, sir. Thank you.
Yes, sir.
We have not been excused by the court.
Okay, I wasn't sure.
All right, Mr. Memori.
Yes, Judge, I've conferred with my client, Judge, and I think we're good to go, Judge. Can we be excused?
Yes, you may be excused.
Thank you. Mr. Courtney, you're excused. Thank you, Judge. Y'all take care.
All right, thank you. Have a great rest of your day.
Y'all too. Thank you very much.
And I'm going to print a document.
There you go.
All right, we're just waiting for Mr. Thornton to come into the main room.
Judge Boyd, is Ms. Hudgens excused?
Yes, Ms. Hutchins is excused.
Okay, thank you so much.
All right, and
Judge, he's under Eric T.
All right, just give me one moment, Mr. Hernandez.
Judge, I think that was all you needed CTD for. Can I be excused to go back to the other Zoom link?
Yes. Yes, I believe Mr. Thornton, is he with Ms. Hayden?
Yes, I'm taking care of him. And then we've got Carlos Garcia's sentencing. I think he's just in the courtroom.
Yes. All right, thank you. All right, we're going to go back on the record, Brenna. Yes. We're going to go back on the record on 2021 CI 13023. If I can have parties announce.
Yes, Your Honor, the petitioner is Jacqueline Janice and Olivia.
Michelle Hayden for the state? Or
No.
wait, this is okay, sorry.
No problem. All right. For the petitioners.
Olivia Thayer and Jacqueline Janice.
And for the respondents?
Charles Martin and Justin Morgan.
All right, the court is in receipt of a jury question, and it's been signed by the foreman. The question is, has he been on his regular medication on this trial? Have both parties had a chance to review that question?
Yes, Your Honor.
Yes, Your Honor.
Off the record, we discussed the agreed upon answer. Have both parties seen the supplemental charge, which would state, members of the jury, with reference to your inquiry, the court instructs that you have before you all the evidence that was admitted in this case, and you are instructed to continue your deliberations. Have both parties had a chance to review the proposed supplemental charge? Petitioners?
Yes, Your Honor.
Respondents?
Yes, Your Honor.
Any objection?
No, Your Honor.
None for respondent.
All right. Is there any objection to having the deputy send this supplemental charge back to the jurors in the jury room? Or would parties request that the jurors be brought out and read the supplemental charge? Petitioners?
No objection to having it sent back.
Respondents?
I agree. No objection to sending it.
Right, and we will go off the record. And then now we will go on the record on Eric Thornton. Am I muted? Thank you. All right, the court is going to call 2022 CR 2589W, State of Texas versus Michael Thornton. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Tony Hernandez for the defense.
And are you Eric Thornton?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Thornton, I'm going to show you a document entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video conference. Next, I'm going to show you a document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, Your Honor.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm going to show you what's entitled Application for Deferred Adjudication. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Thornton, I'm going to show you what's entitled Information. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Mr. Thornton, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with repeated violation of court order of bond conditions, family violence? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form, I'm sorry, I'm looking at two different things, Brennan. Just 1 second. Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Thornton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargaining agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm going to show you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, there's a $1,500 fine. State recommends deferred adjudication. They will take in consideration 2022 CR 2344, County Court Cause number 666300. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There'd be a TAP evaluation, 150 hours of community service restitution, and no contact with Catherine, Katherine Thomas. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense is charged in the information. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
State offers State's Exhibit 1 and its attachments into evidence.
Any
No
objection?
objections, Your Honor.
Mr. Thornton, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I think Eric is aware of his responsibilities under the plea agreement and what he needs to do to be successful. He's working now. He's been on the monitor for quite a long period of time now, and he hasn't had any violations. We're asking the court to follow the agreement, Judge.
All right, Mr. Thornton, do you have any children with Miss Thomas?
No, ma'am.
All right, she doesn't want to have contact with you anymore, and the court is ordering no contact. Do you understand?
Yes, Your Honor.
So there's no reason for you to contact her. Do you all have any type of property together?
No, Your Honor.
So, and when the court says no contact, that means not calling her from different phones, like I've read in the police report, not having third parties contact her, not sending her, I guess, what holiday is coming back, Easter cards or anything of that nature, asking for forgiveness. That relationship is over and you're not to have any contact with her. Do you understand?
Yes, Your Honor.
Are you employed?
Not yet, but I'm starting a new job Tuesday.
What are you going to be doing?
It's a nonprofit, training service dogs for wounded warriors.
Okay.
Yeah, it's a real rewarding job.
Let me see, this computer is asking me if I want to shut it down, but I'm like, no, we're gonna have to put that on snooze. All right, 3 years deferred adjudication, $1,500 fine, that'll be probated, taking consideration 2020 CR 2344, County Court Cause number 666300, no contact with Catherine Thomas, employment within 15 days, no employment as a home healthcare provider or with minors, regular UAs or patch.
Okay.
Field visits, 1 time per month. Regular reporting by Zoom or in person. So what that means is if for some reason you can't Zoom, then you need to report in person.
Okay, yes, Your Honor.
150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. That includes the booster. The court is not requiring you to take the COVID vaccination, but if you do, 40 of those hours will be deducted from your community service hours.
Thank you, Your Honor.
Right. I'm going to keep him on GPS tracking for 2 more months, Mr. Hernandez, and let's see how things are. And then once he gets in a routine, then the court will remove that. So, Mr. Thornton, if there are no other, if there are no violations on that GPS in 2 months, and I'm going to put it on tracking only, then you'll be removed from it. And
So he'll be free to work, Judge, and go about his business. He just has to, it's a restricted zone. Is that what we're talking about?
no, it just is tracking only, just to see where he is.
Oh, okay.
And Ms. Reyes, if you can, or the state, if you can let the complainant know that he's still on GPS, but it's tracking.
Okay.
And Mr. Thornton, before I remove the GPS, state and probation, the complainant will have to be informed, and I'm going to want the complainant's input if she has some issues with that. And of course, I'll end up making my own decision once everything is presented to me. But Mr. Hernandez, you can come back in 2 months and ask for removal of GPS.
Thank you, Judge. And is the court waiving the fees on that, Judge?
I'll put in waiver of fees placed on indigent status.
Thank you, Judge.
Thank you, Your Honor.
Rebecca, is there anything else he needs?
No, ma'am.
Mr. Thornton, is there anything else you need from the court in order to be successful?
I need my monitor removed, but I guess I have to wait 2 months for that.
Yes, you got to prove that you're not supposed to be around Miss Thomas, okay?
Yes, ma'am. I've got 215 days, so.
And Judge, for clarification, Eric understands that if she happens to show up someplace he is, that he needs to leave that location. And if she were to come by his house, he needs to make an offense report.
Yes.
Is that what the court would prefer to document, that just in case those issues come up?
Yes. All right, Mr.
Thank you.
Thornton, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, Mr. Thornton, what are the about to be tiers for?
I'm not sure. Just ready to get my life back together.
All right, so I mean, getting that life back together, that means that she is no longer in your life. Do you understand?
Yes, Your Honor.
And you've heard the relationship speech that I've given other people. How old are you?
38.
All right, so it's not like, even though it's no excuse for children to be doing it either, you are a 38-year-old man. When people end relationships, they're over, move on. You still have a majority of your life in front of you. A majority of my life is now behind me, unless I'm planning on living past 100, which I hope so, but we'll see what happens. All right, I'm going to send you to a breakout room. I'm going to send you to breakout room number 1. And probation will go over those conditions with you.
Okay, thank you, Your Honor.
You're welcome.
Thank you, Judge. May we be excused?
Yes, you can be excused from there. Mr. Valdez, I'm going to put you in a waiting room. We have a verdict on a jury trial, so just give me a moment.
Okay, Judge. And Judge, you're still a young whippersnapper, as my dad used to say.
Hey, I like that.
Hey, Judge, we have a pretrial going on. Can you all just text me to hop in on Carlos Garcia?
Yes.
Okay. All right. I can definitely sign back in for that. I just she's been waiting a little bit, so I didn't want to. I figured I should go over there and check in.
Sure, no problem.
Okay, thank you.
All right, let me just find this to put you in a waiting room, Mr. Valdez, but I'll be able to see that you're still there. All right. And then- it's the court's understanding that you've reached a verdict, is that correct?
Yes, you have your right.
And is that verdict unanimous?
Yes.
Okay. And Deputy Laura, if you would pass that to me, please. Right, the verdict form appears to be in the appropriate order. Mr. Rivera, if you could please stand. Verdict form, do you find beyond a reasonable doubt that Joaquin Rivera is a sexually violent predator? Answer, yes. And the verdict has been signed stating that the verdict is unanimous. And just for the record, is the verdict unanimous?
Yes.
All right, you may be seated. Would you like the jury polled?
No, Your Honor.
All right, ladies and gentlemen of the jury, thank you so much for your time in this case. If you will retire to the jury room, I'll meet you there briefly. Everyone, please rise for the jury. All right, everyone, please be seated. Oh, would you like to have some time to speak to your client?
Yes, I need to go some paperwork.
Okay, all right, I'll let you do that. And everyone, just give me a moment. I'm going to go on a brief reset. Mr. Piddle, no more than 5 minutes. Yes, All right, we're gonna go on the record in 2021 CR 4352, State of Texas versus Carlos Ramirez Garcia. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Kelly Piddle.
And are you Mr. Garcia?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic, but the court will note for the record that the defense attorney and defendant are in the courtroom. Is there any objections to this sentencing taking place by video, state?
No, Your Honor.
Defense?
No.
Mr. Garcia?
Yes, ma'am.
All right. Mr. Garcia, according to the plea bargaining agreement, you entered a plea of no contest. The court found there was sufficient evidence to find you guilty. And you enter a plea of no contest, the offense of indecency with a child contact. Court will follow your plea bargaining agreement. Court will sentence you to 4 years in the prison. Give you credit for any time served. Chapter 62 registration. And there's an agreed protective order for Avery, Avery, Garcia until she turns 18. And that's 18 years of age. Is there anything else from either side with regards to sentencing defense?
No, Your Honor.
State?
No, Your Honor.
Mr. Garcia, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon is or ammunition, you need to discuss that with an attorney. Do you understand?
Yes, ma'am.
All right, with that, we'll close the record on this case. Good luck to you, Mr. Garcia.
Thank you.
You're welcome. The parties on David Morales.
Brittany
The
Judge.
judge.
Okay, court is calling 2021 CR 11287, State of Texas versus David Lee Morales. Can I have the parties announced for the record for the state,
Brittany Sparks.
for the defense?
Jerry Valdez Jr. for Mr. Mireles.
And are you Mr. Morales?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Morales, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Court will find that
Yes, Your Honor.
defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Morales, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Morales, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did.
Again,
Your
did you
Honor.
understand you have a right to jury trial, a right for you or your attorney? Just 1 second, off the record for a moment.
I've been working at weekdays on military since I've been released from jail the last time. So from August to now.
Yeah,
Full time.
they just called me. I'm sorry, they just called me.
Please. All right, we're back on the record in 2021 CR 11287. Did you understand you're charged with evading arrest, detention in a vehicle? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I do.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I do, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, he was, and he is.
Mr. Morales, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No.
Has anyone
No, ma'am.
promised you anything other than the plea bargain agreement to get you to enter this plea?
You say it again, please.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review this page with your attorney? Did you understand it?
Yes, I did.
According to the plea bargain agreement, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. The state is taking into consideration 2021 CR 11284, grand jury number 750094, grand jury number 70095, and there is no applications for community supervision or deferred adjudication. Did you understand that to be the plea bargain agreement?
Yes, I did.
Defense is at the plea bargain agreement.
That is the agreement, Your Honor, that we have.
State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Into the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
Just one moment. All right, we're going to go off the record for a moment. Can you mute me, please? I'm going to send something into the chat to everyone.
Ahí viene tu abogado, okay? Don't touch nothing. Thank you. Will you go in?
So do you all see my chat? All right, so that needs to be corrected. And then on Mr. Rivera, there is a trial court certification in the box. If you could grab that for me, please, counsel. And it should say trial court certification of defendant's rights to appeal.
Judge.
If you could have your client sign it, and then I'll put on the record
Okay.
the appeal issue.
This is dealing with a criminal case, is that
Yes,
okay?
yes, that's fine. That's the only one we have.
Okay.
And so I just want it to be in writing that he understands he has a right to appeal.
Jurisdiction is on the 14th, we start on the 15th.
Yes. (21) CI 13023. Parties, could you announce for the record, please?
Yes, Your Honor, Olivia Thayer and Jacqueline Janice for petitioner.
Charles Martin and Justin Morgan for respondent, Mr. Joaquin Rivera, and Mr. Joaquin Rivera is also present.
All right, and the court has been presented with a final judgment in this cause number. Any objection to the final judgment, respondents?
No objection to the form of it.
And also, Mr. Rivera, are you in receipt of what's entitled a trial court certification of defendant's rights to appeal?
Yes, ma'am.
And did you have a chance to review that with your attorneys?
Yes, ma'am.
All right, because this is not a plea bargain case, you do have the right to appeal. Do you understand?
Yes, ma'am.
And have you had time to discuss the right to appeal with your counsels?
Yes, ma'am.
All right, do you have any questions about anything, Mr. Rivera?
No, ma'am. Not at this time.
All right, thank you.
Yes, ma'am. Thank you.
Then with that, if there's nothing else from either party, then we will close the record.
Thank you.
All right, thank you. All right, Mr. Valdez, I'm just waiting to receive that paperwork.
Where am I? Okay, Judge, I just reviewing the paperwork.
Bien, ¿usted cómo está, oiga? Ahí. Ajá, ajá, sí.
Thank you. Is there a way we can
We'll see if we can get you that certified before we leave.
I know they're gonna want at least 2 copies, right?
Yes, if we could get 2 certified copies.
And we just need 1. Sorry, yeah, sure.
All right, we're back on the record and cause number 2021 CR 11287. Mr. Morales is showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand, right? And did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, this was a family situation that got out of hand, and Mr. Morales is taking responsibility. He's asking the court to follow the agreement that we have with the state.
All right, Mr. Morales, I'm going to send you to 3 years in prison, give you a $1,500 fine, time and money.
Okay.
Take in consideration 2021 CR 11284, grand jury number 75009.
Écheme la mano, abogado, como quiera yo saliendo. Usted me va a ver en persona y va a ver que yo me pongo a mano con usted también, abogado. Écheme la mano lo que pueda.
Is there anything else we need to start with regards to sentencing?
No, Your Honor, he's just asking that he gets his credit for his time. So I didn't hear you if you did that. If you said that.
Okay.
Yes, I did.
Me lo bendiga mucho, oiga.
But hey, I'm learning Spanish, so that's always good. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, I did, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, I do.
All right, with that, we'll go off the record. Good luck to you, Mr. Morales. Mr. Morales, did that tattoo hurt?
No.
What were you thinking when you got that under your cheek all the way to the top?
I don't know. I don't know.
Are you going to be thinking about getting a matching one on the other side?
Nah, I'm thinking about putting a motive on the bottom.
Motive, okay. All right, you know what, to each his own. You know, people say the body is a work of art.
Yeah.
So do you have any children, Mr. Morales?
Yes, I do.
How many?
I have four children.
What are their ages?
My daughter's the oldest, she's 15. She barely turned 15, and I have 3 boys. They're 12, 9, and 7.
Okay, how old are you?
I'm married 34.
All right, so you get into that point, you're not there yet. You get into that point where you're going to have more of your life behind you than in front of you. Don't be the person at the Bexar County Jail or at the prison where people say, how do things run here? And they say, as the oldest person here, we call him Grandpa Morales. Don't be Grandpa Morales at the prison, okay?
Yeah, all right.
All right, good luck to you.
Thank you,
Good luck
Honor.
to you, Mr. Morales. You're welcome. Have a good day.
You too.
And Judge, here's another riddle for you as far as your age.
Okay.
My father used to always tell me also, I'm old. He used to, we used to ask him when we were younger, I say, Dad, how old are you? He goes, I'm old as hell, well, not old as dirt.
Okay, I'll remember that. I'll use that one. Thank you. You made my
And
day.
it's a riddle. You have to figure it out.
Okay.
Thank you, Judge.
Have a good one.
Bye.
Bye-bye. And we're going to start back up at probably 2:15, so everybody can have a lunch break.
Judge, are we all logging back onto this Zoom?
Yes.
Okay.